All rise. Hearing, hearing. The Court of Appeals for the First District of Texas is now in session. Pursuant to adjournment, God save the Constitution and the Honorable Court.
Please be seated. Welcome to an in-person session of the First Court of Appeals. We have one case on today's docket, case number 0120007000-CV, Maddie Jones individually et al. Versus Harris County et al. Can I have the appearance of counsel for the appellant?
Yes, Carly Milner here for Maddie Jones, along with James Morrow and Jazz Brar.
And you'll be the only one arguing?
That's correct.
And for the appellee?
Michael Hall from the Harris County Attorney's Office for Harris County.
Thank you. And you want to reserve 5 minutes for rebuttal?
That's correct, Your Honor.
All right. You may proceed when you're ready.
May it please the Court. The county's argument in this case, fundamentally, is that the accessibility of public facilities to disabled persons is a matter of discretion. The ADA, the Texas Accessibility Standards, and the Texas statute on which those are based, say otherwise. It is mandatory to provide access to public facilities for disabled persons. I'd like to emphasize 2 points today in my argument. The first is the legal standard applicable to pleas to the jurisdiction, which the trial court has applied. And the second is the mandatory nature of the curb ramps.
I'm going to go straight to the second.
Sure.
To the mandatory.
I would be happy to do so. I hope that our supplemental brief provided some of the answers that the court was looking for. But just to reiterate those points. The ADA and the Chapter 469 of the Texas Government Code are very similar. They both provide that public facilities must be accessible to persons with disabilities. There are not blanket exceptions to this. It is not a discretionary requirement. It is not like other safety standards that are a matter of judgment. In many of the cases that the county cited to this court and to the trial court, the cases involve things like whether a guardrail should be in place, whether a road should have a median or not. Those are issues of design that are generally left up to the engineers designing the roads. But the ADA is not a design choice. And I'd like to call the court's attention even to the letter to the parties inviting us to oral argument here today, which says persons with disabilities who plan to attend this submission and who may need auxiliary services should contact the clerk's office at least 2 days before submission. And that statement is in there because the government must make reasonable accommodations for people with disabilities.
Wasn't there a very specific statute or regulation, particularly 28 CFR section 35.151 little I1, regarding the, when curb cutouts, ramps need to be installed. It has to be run, but only when there's a pedestrian walkway, e.g. a sidewalk, to be accessed from the street.
And there was a pedestrian walkway in this case. The issue in this case is that Mr. Jones was on one sidewalk attempting to cross a road to the other sidewalk. There was a curb ramp on one side, and this was at night. He got across, and there was no curb ramp on the other side, so he could not access the sidewalk and had to go in the road to the driveway to be able to access, to get off the road.
Is there an exit?
Sorry. I think we're going to ask the same question. Is there a depiction of this intersection? The only one that I have found in the record is at CR 68. And if you see a sidewalk there, I'd appreciate you showing it to me. But I don't see any depictions of that unless you can point me to one in the record.
You are looking at the only picture that is in the record. And I think this actually goes to the other point that I wanted to make is the standard for the plea to the jurisdiction in this case. If there is a question about whether the ADA applies to this particular intersection, the plaintiff must have an opportunity to amend. Unless she pled facts that conclusively exclude the possibility of jurisdiction, the trial court cannot grant the plea without giving the plaintiff the opportunity to amend. And when we talk about cases that conclusively exclude jurisdiction, one example I found is when a plaintiff brings a breach of contract case against a governmental entity. There is no waiver of sovereign immunity for a breach of contract case unless there has been a special legislative enactment particular to that. So that's a case, and I can actually provide you a cite to that example if you'd like. There's a case from the Texas Supreme Court, the Texas A&M University System versus, and I'm probably mispronouncing this person's name, Kazio. The site is 233 Southwest 3rd, 835. The court does a good job of explaining the difference between cases in which the plaintiff can replead to add jurisdictional allegations and cases in which repleading would be futile because there is no set of facts under which immunity could have been waived.
Well, let's think about that standard for a second. I mean, the evidence that we have in the record, we don't have any evidence that there was a pedestrian walkway there. So you could perhaps plead there was a pedestrian walkway there, but would that be an accurate pleading?
That is something that has to be returned to the trial court for there to be a chance to replead. It's not that the plaintiff must show in response to the plea that these facts exist. And for example, some of these facts may require discovery, but the court here granted the plea on submission after the plea had been on file for 11 days and there had been no discovery taken in the case.
Did you move to replead?
The plaintiff did request a replead, and the plea was just summarily granted on submission. And there's also a discussion in the A&M University case about what it means to give a plaintiff a chance to replead, and it is not simply that a plea to the jurisdiction was filed and the plaintiff could have chosen to replead. The plaintiff has a right to stand on its pleadings and determine whether the court is going to grant or deny the plea to the jurisdiction pending repleading.
Is there anything in the record indicating when this intersection or this curb was built?
There is not, and I know that that is an issue that was raised by Harris County. That is another issue that can and should be addressed by repleading if the court finds that pleading the date is necessary. One thing I would call your attention to is that the Texas accessibility standards implement the Chapter 469 of the Texas Government Code, which actually applies to roadways that were built or altered since 1970, which is now 52 years ago. And it is, given that the trial court was required to interpret all facts in the light most favorable to the plaintiff, it is a bit difficult to believe that these roads in Harris County, if they were drivable, have not been constructed or altered in the last 50 years. So we don't view that as an obstacle to pleading jurisdiction.
It doesn't only apply to new construction?
No, it applies to new construction and alteration.
And to what level of alteration?
We cited in our supplemental brief the Jones versus White case, which is a Judge Rosenthal decision from the Southern District of Texas, but applying the same, or looking at the same governmental sovereign immunity issues with respect to curb ramps. And in that case, the court found that even just repaving a street can be the minimum level of alteration needed to require a curb ramp installation. So even, I mean, I think we all drive around Harris County all the time. A street that has not been repaved in 50 years is a bit unlikely.
Was the operative date 50 years ago or 1992?
It's 50 years ago for the Texas statute, and it's 1992 for the ADA. And as someone who graduated from high school in the 1990s, I'd like to think of that as a long time ago, but it was also about 30 years ago. So again, viewing the facts in the light most favorable to the plaintiff, it's certainly reasonable to believe that the road was constructed or at least repaved in the last 30 years.
Well, what facts or pleading would give rise to that inference?
The fact that the road was drivable and had a car on it would imply that it has been maintained in the last 30 to 50 years. But again, that is an issue that is subject to repleading. That is not, the plaintiff has not pled, for example, that this road was constructed at a time where these statutes would not apply, or that the road was constructed in 1940 and has not been altered since that time. That would be a situation in which the plaintiff had affirmatively pled herself out of jurisdiction. But here, if there's simply a question about what the fact is and whether there is a fact that would support or negate jurisdiction, that is something that requires leave to amend, not dismissal.
I just ask, if you were to describe, based on what's in the record, where the decedent was going to and from at the time that he was struck, can you do that?
Yes, my understanding is that he was in his wheelchair on the sidewalk on the road headed towards a shopping center. He had to cross the road that we're talking about to get to that shopping center, exited the sidewalk on the curb ramp, and then that there was no ramp or anything to allow him to get out of the road on the other side. And so he was in the road headed towards the driveway where he could get out of the road when he was hit.
Was he traveling with or against traffic at the time he was struck?
I believe he was traveling against traffic, as a pedestrian would do.
On the left-hand side of the road?
If they were in the road, that's my understanding.
So, where on the record is some evidence that there was a curb ramp, that he used a curb ramp when he got onto the roadway?
And that is in the petition, and just give me one moment. He was, on page 6 of the record, there's a description of him using a wheelchair to cross Oakwood Glen Boulevard at the intersection with Stubner Airline, and he was able to get into the crosswalk on one side, but was not able to exit due to the lack of the curb ramp on the other side.
Any other questions from the panel?
No.
All right. Thank you very much, Ms. Milner.
Thank you.
Mr. Hall, you may proceed.
May it please the court, I'm Michael Hall, as you know, with the Harris County Attorney's Office, and I represent Harris County in this case. Unfortunately, you've probably seen, and why you've added oral argument, is it's a difficult record in that it's sparse. Frankly, the plea is poorly drafted. I'd like to talk about the gist of what the plea is, but first of all, obviously you have concern about 101-056, the discretionary act. I'm going to be honest here, and it's tough. Because of the state of the facts, the record, the facts in the record, and because of the law, I'm not sure 101-056 is applicable in this case at this point. It may be. The problem is I'm not sure the Texas accessibility code even applies to ramps. It mentions ramps, but it seems to be speaking in terms of buildings. And it also says if there's a ramp, it has to comply with these things. Similarly, if you look at TxDOT's ABA curb ramp and sidewalk guidance, they talk about places where there's a marked crosswalk, and they say, you know, sometimes that's not something that needs a ramp. It says the ADA does not require installation of ramps or curb ramps in the absence of a pedestrian walkway with a prepared surface. But then you talk about what was the intent of the design. Was the intent to give access through the crosswalk? We don't know that. There's nothing in the record. We don't know when the roads were built. We don't know if it's been maintained such that it comes within the ADA. We don't know anything, and I happen to agree, it's a little early for a plea to the jurisdiction on 101056. That's problematic. In addition, in the ABA toolkit, again, they talk about sometimes curb ramps aren't required because of feasibility issues. And in some instances, through contract or through deed restrictions or plat approval or whatever it may be, maybe it's the property owner, the other two defendants in this case that were responsible for the curb. You know, we just don't know. I don't know. There's nothing in this case. But what I do know is the pleadings in this case pleaded a special defect, and it pleaded negligence claims. Those negligence claims aren't available under the Texas Tort Claims Act. When it involves an issue involves real property, either it's a premise defect claim or it's a special defect claim, and that's all there is under 1010212. And in this case, they clearly pleaded a special defect claim. The plea to the jurisdiction said they pleaded a special defect claim. Their response agreed that it was a special defect claim, as did their serve reply. It is a special defect claim. They've doubled down on every one of those. And this, which is a legal question, is not a special defect. This is something that's been there a long time. This is something that isn't an unexpected, you know, a hole in the road or a barrier or something like that. It's simply not, as a matter of law, a special defect. And that's all that was pleaded. This court's case in City of League City versus LeBlanc said the test for whether a condition is a special defect is whether the condition is of the same class as an excavation or obstruction on a highway, road, or street, and there's no requirement that the condition pose an unexpected or unusual danger, okay? But you added, the court added, a long-standing, routine, or permanent condition is not a special defect. So if these roads are as old as counsel claims they are, that curb's been there that long too. It's simply not a special defect. It's got to be something that the complainant wasn't aware of, the plaintiff wasn't aware of. And in City of League City, the storm sewer at issue there that had a bad grate was installed in 1985, so the court held as a matter of law that's not a special defect. And in this case, we were talking about pleading. They did mention there's a statement or sentence in the response to the plea of the jurisdiction that says, well, alternatively, let us replead. Nothing stopped them from doing it. They could have repleaded. You know, we're now almost 2 years into the case, and we still don't have an amended petition. We don't have anything new. But then I question, what could they add? You know, in light of the law in LeBlanc, what could you possibly add that would create jurisdiction, that would come within a waiver under 101021? I don't see how you can. It's not a special defect. It's not a premises defect. Whether it does or doesn't comply with the ADA or the Texas accessibility standards under 101021 is completely irrelevant. So I think the court should affirm just on that ground. I don't think you need to reach the 101056 question. And I'd add to that, I was not the trial attorney, and I actually didn't draft the brief in this case, so I'm kind of new to, even though my name's on the brief, a lot of moving around at the county attorney's office. But as I was researching for this argument, I ran into something new. The Texas Human Resources Code provides causes of action, you know, the standards, that sort of thing for the accessibility standards under the government code. Under, you know, let me just point it out to you. It applies to the right to sue under 121.004 of the Human Resources Code, permitting suit in some instances regarding Chapter 469 of the Government Code or any other state or federal law that deals with accessibility. So this is Texas's take on when you can and when you can't sue. And specifically, it requires a specific notice served like a citation, it specifically says, basically naming the claimant, the respondent, the incident, when it happened, very specific things. And it also requires the plaintiff not demand a sum for damages, request settlement, or offer to settle a claim without a determination of whether a condition stated in the notice is excused by law or may be remedied. Then it specifically provides that the respondent may remedy the condition. And if the respondent remedies the condition, by the way, this is 121-0041.
Was this presented to the trial court?
Nope, it was not. I ran across it while I was doing this.
So it's sort of a new argument on appeal.
Yeah, but I think it goes to show that I don't know if it robs the court of jurisdiction or not, to be honest with you. I ran across it, it's pretty interesting, and one of the things it says is if the problem is real and it's remedied, you get dismissal. Either the plaintiff will dismiss automatically, or the defendant is entitled to file a motion for summary judgment.
But it's a summary judgment, it's not a dismissal for want of jurisdiction.
Of course, you can do a jurisdictional matter in a summary judgment, Your Honor. It's just a tool. But to add to that, the statute preceding 121.004 basically allows a person to sue under the accessibility standards, and it allows presumed damages of up to $300 or more. But nothing in there waives sovereign or governmental immunity. As you know, under 311.034 of the Code Construction Act, any waivers of immunity must be clear and unambiguous. So, to tie it all in, I don't think there's jurisdiction to sue the county for damages under these provisions. Now, you may be able to sue for injunctive or declaratory relief. That may be, but it's a very limited. The damages structure is very limited, and it wasn't complied with here, and the county has a chance to remedy it if, in fact, it is a violation. And without that, I would argue that 121.004 simply doesn't waive immunity from suit under sovereign or governmental immunity. And I don't like raising new claims on appeal, but it is a jurisdictional question, so I think I should put that to you. Because when we go back, it'll be raised again, for better or worse. But I don't think the pleadings are good enough to get around the discretionary exception to waiver of sovereign immunity, but I do believe that further discovery on that is merited. However, all they have is a special defect claim, and a special defect claim as a matter of law is not tenable in this cause of action. It simply isn't. That's all they asked for, that's all there is.
And you agree there was no discovery conducted prior to the plea to
There wasn't, no, Your Honor. I mean, with their petition, they filed some requests for disclosure. I don't remember what all, but there was some discovery there. Whether it was ever responded to, I don't know, Your Honor. I'm inclined to think it wasn't, but they can answer that, I guess.
Was there an oral hearing on the plea to the jurisdiction?
I wasn't present, Your Honor. I believe it was an oral hearing, but they may be able to answer that too. Like I said, I just got this case. So there's no reporter's record from the hearing. I know that. So there was no evidence orally taken. Honestly, Your Honors, that's all I really have right now. I'd be glad to answer questions.
Sure. I'd like to ask the same question to you that I asked to counsel, which is, can you describe from the pleadings and from the record where the decedent was coming from, where he was going to? What was his condition when he was struck by the vehicle?
I cannot, Your Honor. All I have is the pleading as well, their petition. I have nothing else.
But the record too. I mean, what's in the record? Can you?
There's nothing in the record. As far as that
Isn't there
goes.
some testimony in the record about the?
The only testimony that's in there is from their expert, and as far as I can recall, he just basically recites allegations that may have been in the pleading. I know of no police reports or there were no depositions. There's nothing like that, Your Honor.
Can you tell which side of the road he was on when he was struck?
Not at all, Your Honor. I'm sorry. Your Honor?
No.
Oh,
I have no further questions.
Okay. I'd ask
for
Your
your
Honor to affirm. 101-021 bill.
Ms. Milner, are you prepared to address the jurisdictional argument that was just discussed?
With regard to the Human Resources Code, I'm not, and I'll note that, well, except for one point that I'll make, but the county did not file a supplemental brief in response to ours, so they had a very recent chance to make that argument and didn't do so. But in that Jones versus White case that we cited in our supplemental brief, that
See,
was...
we're constrained because I mean, if it's, no matter when it's raised, we have to consider jurisdiction. So I'll ask for each of you to file within 7 days, 3,000 word brief with your arguments on jurisdiction on the Human Resources Code.
may I ask that the county file theirs first so we know what argument they're making?
All right, 7 days, then 7 days after that.
Thank you. The Jones versus White case that we cited was brought under the Human Resources Code, and in that case, the city of Houston was found liable and also required to pay damages. The damages were nominal because the person was not physically injured, but that is in our briefing. And here, of course, this can't be remedied by construction because Mr. Jones is dead. I will note with respect to counsel's primary argument on the special defect, Ms. Jones did not only plead a special defect. The Texas Tort Claims Act provides for a waiver of immunity of any kind of premises defect for which a private landowner would be liable. And that comes in two varieties: a licensee claim and then what is called a special defect claim in the context of a government entity. And she did allege a special defect claim, but she also alleged a claim under the licensee standard. She pleaded that the premises were owned by Harris County, that they were defective because one side of the crosswalk lacked a ramp or curb cut to allow wheelchair access, that this defect caused Mr. Jones's death, that this was an unreasonably dangerous condition because it required a wheelchair-bound person to use the road to find a driveway entry rather than a ramp. And she also pleaded that Harris County knew of this defect but deliberately failed to correct it or to warn Mr. Jones. And I think maybe the confusion from the county is that the Texas Tort Claims Act provides a description of this licensee claim, and part of it requires gross negligence or willful or wanton behavior, which Ms. Jones did also allege, and then separately allows an allegation of a claim under this licensee standard based on an unreasonably dangerous condition and a failure to warn. I'll also point out that with respect to the pleading standard that is applicable here, it is a low bar. Ms. Jones pled that the county was required to install a curb ramp at this location. The county had the option to present evidence contradicting her allegations. They did not do so. Nonetheless, in response to the plea, Ms. Jones submitted an expert affidavit which affirms the need for a curb ramp at this location based on the law.
Did the county file special exceptions at all?
I don't believe so, but if they did, they were not set for hearing and were not heard. This matter was heard by submission. That's in the record at page 108. And the county had also filed a request to stay discovery while the plea was pending. It was only pending for 11 days, so that was not really a real issue. But I think even, as you heard from the county, there are a lot of factual issues to be developed here. And Ms. Jones' claim should not be dismissed based on an incorrect application of the standard applicable to the plea for jurisdiction. She must have an opportunity to replead if there's any question about the facts. The county is free to reassert its plea to the jurisdiction, either as a challenge to the pleadings or with evidence, and the trial court can proceed from there.
So to the extent that you made a motion to replead, was that ever set for submission or for oral hearing?
It wasn't a motion to replead. It was a request as in the response to the plea to the jurisdiction. Ms. Jones asked in the alternative that the court allow her to replead, and the court just denied that request when it granted the plea. And again, with respect to whether she did what she needed to do to preserve a right to amend, I would ask you to look at that Texas A&M case at 233 Southwest 3rd 835, which details that the court must affirmatively give the plaintiff a chance to replead after looking at the plea to the jurisdiction. It's not on the plaintiff just to sua sponte replead or to file a motion for leave to replete. That's something that must be granted. And I'm out of time unless you have any other questions.
Any other questions from the panel?
No.
All right,
Thank
thank you very
you so
much,
much.
counsel. Cause number 0120007000CV, Jones versus Harris County is submitted, and the First Court of Appeals is now adjourned.
All rise.